Okay, we are live. Hi everyone, I'm Sean Michael Morris, the Digital Community Organizer for Adjunct Action Network. For those who aren't aware, Adjunct Action is the higher education organizing arm of the Service Employees International Union. The Adjunct Action Network is a member-driven effort to raise the standards in higher education and the teaching profession. Our philosophy is that the more people we reach, the more people we'll affect. Today is part 2 of the network's organizing bootcamp. Our session today will discuss your legal rights and protections while organizing. And joining us today is wow, I totally just spaced your name. I'm so sorry.
That's
Saerom
okay.
Park, an attorney advising the Adjunct Action campaigns. Thank you so much for joining us today.
You're welcome. I'm excited to be here.
Yeah. I'm going to go ahead and get the slideshow going here, and then we can get going.
So hi, everyone. My name is Saerom Park. I'm a law fellow attorney here at SCIU in the General Counsel's office, and I work, as Sean said, with organizers and local unions around the country who are participating in this exciting movement to organize. So I'm excited to be here today to provide a basic overview about labor rights under the National Labor Relations Act, which covers private sector employees. So next slide. So here's the overview. We'll cover 4 main topics. I'll talk a little bit about the National Labor Relations Act, and then we'll dive into your Section 7 rights, which are really the heart of the Act. We'll talk a little bit about employer unfair labor practices, which we call ULPs, and I'll end by saying a few words about collective bargaining. And I just want to note that this is a presentation for informational purposes, and it's not for the purpose of providing legal advice, and I would recommend that you talk to attorneys if you are facing a legal issue. Okay, so next slide. So I wanted to set the stage by noting what the default rule governing employer-employee relationships has been in this country, and that is employment at will. If any of you have seen Office Space, it's a 1999 comedy. It's really funny, and I would recommend everybody watch it. You know who these gentlemen are. They are the Bobs, and the Bobs are here to find efficiency gains, and that pretty much means layoffs. For me, the Bobs are a predictable outcome of the employment at will concept in a workplace. Employers can fire employees for any reason. Doesn't have to be a good reason, or so long as it's not an illegal one. Or better yet, they can fire you for no reason at all. The employee side of this arrangement is that employees can leave their jobs. If that seems a little unequal to you, then you're in the same camp as the generations of organizers and worker advocates who have fought to even the playing field. So next slide, the National Labor Relations Act, next slide, is truly an extraordinary federal law. It was passed in 1935, and it's commonly called the Wagner Act, for New York Senator Robert Wagner, who championed the bill. The first section of this act notes that the problem it's seeking to solve is the inequality of bargaining power between employees and employers. And there's a little image there of Norma Ray, another great union movie and organizing. She's does an amazing job. Sally Field does an amazing job in that movie. Also another great one to watch. So next slide. The first section goes on to say that it's actually the policy of the United States to address this problem of the inequality of bargaining power by encouraging collective bargaining and giving workers the freedom to organize. This is not an act that mandates any sort of minimum working conditions or designates certain outcomes for all employer and instead, this act is about protecting a process for 2 parties to bargain with each other in a fair way. And I'll note also that the act covers only private sector workers, private sector employment relationships. So public employees, so federal, state, local, public government employees are covered under other state or federal laws. Next slide, please. So the National Labor Relations Act created the National Labor Relations Board, an independent federal agency to enforce the act. And the National Labor Relations Board is comprised of 2 sort of separate parts, and one of them is the 5-member which acts in a sort of judicial function. The members essentially decide cases on the basis of formal records and administrative proceedings. And they have administrative law judges across the country who sort of act as the trial judges and initially take in the cases. And then separately, sort of independent from the 5-member board, is the general counsel side. And the general counsel's office, they're basically the prosecutor, and they oversee the investigation and prosecution of unfair labor practice cases. And they're responsible for processing the cases that initially come in through the 26 regional offices that are spread throughout the country and that are the frontline offices for interacting with the workers and employers. So next slide. The Act protects employees, and there's no doubt faculty are employees. The definition of employee is about as broad as it can get. You can see here it says it shall include any employee and shall not be limited to the employees of a particular employer. But there are some statutory exclusions. So Congress carved out and excluded some specific groups of workers. So you can see, if you click forward, that these include, for example, independent contractors, supervisors, and managers. And as I mentioned before as well, public employees are also not covered under the NLRA. So next slide, I'm going to talk a little bit about supervisors and managers because they come up in faculty organizing. So supervisors are not protected employees under the Act. Supervisors are defined as those who have authority. You can click through. In the interest of the employer to do the following 12 things: to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, or responsibly to direct them or to adjust their grievances. And click through. Or effectively to recommend such action. So you don't have to actually necessarily do that, but that you recommend such action and it's carried out. And the authority is not merely routine or clerical in nature, but requires the use of independent judgment. And so if you do any one of those 12 things, then you may be a supervisor. But if you don't have the ability to use independent judgment in doing those things, then you may not be a supervisor. So for example, if you are responsible for assigning or scheduling other employees or faculty, but you have to follow a strict guideline formula and that you can't use any independent discretion or judgment, then you probably are not a supervisor. So next slide, managers are also not protected under the Act. And this is not in the statute, but courts have read in this exception into the Act because it really didn't make sense that Congress would exclude supervisors but not exclude managers who are even higher in the managerial structure than supervisors. So this exception was really motivated by the concern that employers should be entitled to have some managerial employees who act really solely in their interest, in the employer's interest, and those folks should not have what they call split loyalties. So here's the definition of managers. If you click through, the managers are those who formulate and effectuate management policies by expressing and making operative the decisions of their employers. And click through. They're higher in the managerial structure, and you can click through, and they must exercise discretion within or even independently of established employer policy and must be aligned with management. If this sounds kind of confusing to you, it sort of is, and it's actually been pretty confusing in the higher education context because there's a 1980 Supreme Court decision that found that certain faculty were managers because they made managerial decisions about the academic product of the university through their shared governance system. And this is the case yeshiva. But one erroneous belief that this case yeshiva has created is this assumption that all tenure track faculty or all full-time faculty are managers and do not have protections under the Act. But that is simply not what the law is. I'll note that if you click through, you'll see there's an issue. This sort of summarizes the yeshiva case, and this issue is actually pending before the board currently. And I'll note that it's a SEIU local that is a party in a case that's challenging one university's efforts to label their full-time contingent faculty as managers merely because they participate in a faculty governance system. The law, it's clear that the requirement to be a manager, you have to formulate and effectuate management policies, and that you must be aligned with management, that you're not doing, that you're acting in the interests of management. So, next slide. It's worth repeating here that nothing in the NLRA precludes professional employees from organizing. And in fact, this is a great quote from an important scientist and faculty member himself. Intellectual workers should unite, not only in their own interest, but also, and no less importantly, in the interest of society as a whole. An organization of intellectual workers can have the greatest significance for society as a whole by influencing public opinion through publicity and education. Indeed, it is the proper task to defend academic freedom, without which a healthy development of democracy is impossible. And no less than Albert Einstein said that quote, and he himself was a faculty organizer. So, next slide. Now I want to turn to some of the substantive rights that the Act protects. And these are known in shorthand as your Section 7 rights. So Section 7 reads that employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose and shall also have the right to refrain from any or all of such activities. So if you click to the next slide, I've highlighted the two purposes for which you are protected for engaging in concerted activities, and it's to the ends of collective bargaining and mutual aid or protection. I don't know if the next slide is going to show up, if the formatting might have been off. So it's sort of, if you go back, it's sort of shifted, but basically the collective bargaining part requires a union. That's something you can do once you've formed a union. But your right to engage in concerted activities for mutual aid or protection doesn't require a union, and all employees who are protected under the NLRA can do those things. So next slide. So now you might be wondering whether an action you're about to take is protected by the NLRA. And what you should do is ask yourself whether the answer is yes to these two questions. Is the activity concerted, and is the activity for mutual aid or protection? So is the activity concerted? Basically, this is pretty easy to engage in concerted activities. It just needs to involve other employees in some way. And in fact, the other employees don't need to necessarily agree with you. They may not agree with you, but the act of involving others, engaging others, is what makes the activity concerted. You can click through. For example, if you were to file an individual complaint with a state agency to enforce a statutory right that you have, but it's solely on your behalf, that is not a concerted activity. You may have rights. I'm certain you will have rights to not be retaliated against for doing that, but that activity is not protected under Section 7. So the other question, the other prong you want to sort of check and just double check that you're doing is making sure that the activity is for mutual aid or protection. And you can click through. Essentially, it just means that it needs to be directed at worker or workplace issues. And this has been construed quite broadly by the board and the courts. It doesn't have to be about your immediate employee-employer relationship. And so, for example, if you are engaging in sort of broader political activity to support or defeat some legislation that relates to your interests as employees, that may be considered mutual aid or protection. As another example, if you want to go ahead and click through, this is sort of, not intuitive, but there is a board case where a nurse who reported to a hotline oppressive heat and lack of water, just really horrible working conditions, and did so citing patient safety concerns, that was not protected as mutual aid or protection because it was about the patient safety and not about their own working conditions. So it's a little, it's a little bit of a fine line here. Next slide. But here are some examples of protected activities. So for example, the first one, this is kind of universal. Talking with your coworkers about workplace issues is always protected concerted activity. That's sort of the definition of protected concerted activity. Soliciting your coworkers to take action of some sort during non-work time is protected concerted activity, but slightly different. For example, soliciting might require that the person you're talking to sort of take a break from whatever they're doing at work for even just a little bit to do something, to take that action. For example, to sign petitions or cards. Well, attending meetings or events, not so much, but for example, reviewing some sort of flyer or a letter to the editor. Those kinds of conversations where you're soliciting them to take action are also protected, but your employer might be able to impose some restrictions that they occur during non-work time. Another example is distributing literature. You can distribute literature in non-work areas. Another one is wearing various insignia that are directed towards working conditions. So long as they're not vulgar or disparaging. We'll talk a little bit about non-protected activity. But just to note, employers may limit when or where you may be able to wear paraphernalia and do so in certain industries, but I don't see that as a big problem in the university context. Also, another example is attending peaceful rallies or events during non-work time. Public speaking is another one. And then if you want to go ahead and click through, using social media to engage in protected activity. This is more about a particular form of protected concerted activity. And it's protected, but the board has made a distinction between when employees are just griping about their job or about a supervisor versus using social media to engage in other employees and other workers about workplace conditions. Participating in board proceedings is another example of protected activity, as you can be either a witness or a charging party. All of those things, your involvement in the proceedings is protected. And then work stoppages. Courts have substantially limited workers' ability to engage in strikes and work stoppages, but nonetheless, this right still exists, and that's a powerful thing to just remember as well. So next slide, as you might have deduced from going through that list of examples, your Section 7 rights are not unlimited. The employer has certain rights as well, which the board and the courts will balance against your property rights, your interest in maintaining order and safety at the workplace, work time for work. And so employers are permitted to have reasonable policies that limit your Section 7 rights, and you can think about that in terms of whether they place some sort of time, place, or manner restriction on your Section 7 rights. But the key thing is that they can't be overly broad, that they really eliminate your ability to engage in Section 7 rights at all. And they can't enforce those policies in a way that's discriminatory against just the people who want to engage in concerted protected activity under the NLRA. If they are allowing other employees who might be engaging in similar activity, but it's not for organizing or for a union, and they are not enforcing that policy against them, but then they decide to enforce the policy against you for engaging in NLRA protected activity, then that would be a sign of a ULP, which we'll talk about later. So, all right. Next, okay, great. What's not protected? So this might, go without saying, but some of this might not be completely intuitive. Protect activity or statements that are violent or abusive. Similarly, the courts have said vulgar, obscene, or offensive comments or activity are not protected. Also, there are cases that say that activity that's disruptive are not protected. And to give you an example of what that might mean, there's one case where an employee essentially coordinated a shutdown of 40 work terminals at the office. So that sort of disrupted the work and disrupted the workplace. So that's an example of something that would be disruptive. Comments that are defamatory about the employer are not protected. And so here, the standard generally, if you're involved in some sort of labor dispute, is that your comment it should be deliberately or recklessly false. But I think the best practice here is just to make sure you're not saying I think sometimes are comments that are disloyal to the employer are not protected by Section 7. And so disparaging your employer's product or services, even if that statement is true, is not protected. And so, for example, a disloyal statement might be, this institution provides second-rate education to its students. But you can easily communicate your legitimate concerns in a protected manner by rephrasing and saying something like, when this university hires us to teach classes, it's impossible to plan adequately. So here you can see the difference between the first sentence and the second sentence, that you're not disparaging the employer and the quality of their education. Instead, you are talking about your concerns and tying it to your working conditions. So I'll just say engage in any of these non-protected activities, you lose essentially has cost. So I'll end the section on Section 7 rights with some do's and don'ts. You can go ahead and click through. So do engage other employees. The NLRA protects concerted activity, and so you want to make sure you're talking to your colleagues. You can go ahead and click through. Thank you. Remember to tie your concerns to working conditions and to workplace issues, which is the thing that I just mentioned before. And the other thing that you really want to do is make sure to read your employer's policies. Your employer might have policies about the use of work email, the use of campus spaces for non-work related meetings, social media, what you may or may not say, and identify that you work for that employer. And you should also, in addition to reading these policies and determining what limitations there are on your Section 7 rights, you should also note how your employer enforces these policies with regard to other non-work-related activities. So an example of this is, there may be a bulletin board on campus in your department, and there's a policy in your department that you can't post any non-work-related announcements. But in practice, it's everybody uses it for sort of fun announcements. So there may be a baby shower, or your colleague may be fundraising for a charity run, or your colleague is a musician and has a concert next week, and they're using the bulletin board. So in that case, if the employer were to single you out for putting a notice about protected activity, so a union meeting or a rally around working conditions, then that would be sign of an employer violation of your rights. So some don'ts. They're kind of the reverse, but basically of the do's. Don't go it alone. Engage your coworkers about these issues. Don't make allegations about your employer without verifying them. That's just sort of a best practice to make sure you're on firm ground. Don't disparage your employer's product or services, even if true. And then the last thing, that your source of power as an employee is not from the law. It's through organizing. And so these of your ability to go out there and organize, but they don't have any inherent power in and of themselves. So the next topic I'm going to cover is employer unfair labor practices. So you're thinking to yourself, great, I've got these Section 7 rights, but what happens if my employer does something to interfere with my Section 7 rights? Employer takes some sort of retaliatory action against me for engaging in protected activity. Well, that's what Section 8 of the NLRA addresses. It makes it an unfair labor practice for an employer to interfere with, constrain, restrain, or coerce employees in the exercise of the rights guaranteed in Section 7. And it also is an unfair labor practice for an employer in regard to hire or tenure of employment or any term or condition of employment to encourage or discourage membership in any labor organization. I'll also note here that once you organize into a union, it's also a ULP for the employer to refuse to bargain in collectives of his employees. And I'll talk a little bit more about that in the last section. So next slide. So here's an acronym that can help you figure out if your employer has committed some of the most common ULPs that typically come up, and that's called TRIPS. So in order, essentially in order to prove unfair labor practice charges, you have to be able to show that you were engaged in concerted protected activity and that the employer knew that you were engaging in that protected activity and that an agent of the employer did one of these things. So, so the first one is threats. Threats can be direct or implied. They can be specific or unspecified. Essentially like, you'll get in trouble. It's pretty generic, but it's still a threat. Or example of an implied threat would be if they say, remember what happened to Joe, and something not good happened to Joe. But make sure that you are distinguishing between the employer's objective predictions about what might happen and a threat. So it's okay for the employer to say, I predict that if a union comes in, XYZ might happen. So that's not a threat. The second one is, the R in TRIPS, is retaliation. And retaliation, I'm going to go back to this, so let's actually circle back to this in a second. So interrogation is the I, and essentially it's an unfair labor practice for your employer to interrogate you in a coercive manner about your protected activities. So coercive, the coercive interrogation depends on a number of different things, such as who's asking, the method of questioning, the circumstances of where the questioning occurred, what kinds of questions were asked. All those things will go into whether or not it was coercive. The P stands for promises. It's an unfair labor practice to go ahead and promise benefits and solicit grievances, implying that they're going to fix those things, with the purpose of essentially undermining the organizing effort that's underway. And then the last thing, S, is surveillance, and it doesn't have to be actual surveillance. It can be the impression of surveillance. So if they say something like, you know, I know who went to that union meeting last week, or I know who all signed cards, sort of giving the impression that they're spying on you, that is an unfair labor practice. It's not surveillance if your supervisor happens to be walking by and, you know, sees you leafleting with your colleagues. So just making sure to tease out that difference. So circling back to the R, to retaliation. Retaliation can be any against the employee because of the protected activity, because of engaging in activity that's protected under Section 7, and that's discrimination. It refers to the ULP that was discussed earlier about discrimination. Some examples of this might be that there's more stringent enforcement of workplace rules after an organizing campaign starts on a campus. More commonly, you've got, you know, demotions or firing. The more common scenario in a non-tenure track faculty position is that they might not rehire you. They might think you're a troublemaker and not grant you, not reappoint you. And in these types of situations, it is really hard to prove that a ULP has occurred, because it can be really easy for the employer to come up with a non-discriminatory, legitimate reason for not reappointing, because the nature of work regularly is contingent. There may be a number of reasons, legitimate reasons, that the employer can point to for saying they decided not to reappoint a particular faculty member. The challenge at that point to be successful in your ULP charge is to be able to produce evidence that the employer's reason is pretextual, and that it really was motivated by anti-union animus. And sometimes it can be really difficult to find evidence of that smoking gun. So that's something just to keep in mind, but those are the standards that the board is going to look at in order to have a successful ULP claim. So next slide. The ULP process, unfortunately, can be quite lengthy, like all administrative proceedings. This slide sort of walks through what the process involves. You can file a charge with your regional office. There's 26 of them around the country. And you have to file within 6 months of the unfair labor practice happening. The board agents will conduct an investigation, and the regional director of that office will decide whether or not to issue a complaint. If they descend, an appeal, but it's very unlikely that the decision will be reversed. If a complaint is issued, the NLRB becomes a party to the proceeding and will prosecute the case for you, for the charging party. And an administrative law judge will issue findings and a proposed decision. Throughout this whole process, the board is also going to be seeking to have the parties come to a settlement outside of sort of the adjudication. So once the ALJ issues a decision, the parties are able to file exceptions to the ALJ's findings, and then the 5-member National Labor Relations Board, although it may not be all 5 members, but a panel of 3, will either decide to adopt the ALJ's decision or issue its own decision. And then at that point, parties can actually further appeal to the appropriate U.S. Court of Appeals, and also ultimately to the U.S. Supreme Court. So as you can see, this process kind of is quite lengthy. And then next slide, at the end of the day, here are the possible remedies. You could have injunctive relief. The employer stops the unlawful activity. The employer posts a notice in the workplace and it lets all your colleagues know that they engaged in the unlawful activity and that they're stopping. And there's also make whole remedy. So if you were unlawfully fired, the board is empowered to authorize reinstatement and back pay with interest. So I want to end this session, this hour-long webinar, with a few words just about collective bargaining. So next slide, please. So collective bargaining, we talked a little bit about this and referenced this as we were talking about Section 7 rights and about ULPs under Section 8. So just to recap, Section 7, I referred to how Section 7 protects concerted activities for the purpose of collective bargaining. And Section 8 requires the employer to bargain in good faith with the parties. And I just want to step back and put up the definition of collective. So the Act defines this as the performance of the mutual obligation of the employer and representative of the employees to meet a reasonable time with faith with respect to wages, hours, and other terms and conditions of employment. So we have a statutory right as employees to bargain about wages, hours, and other terms and conditions of employment. Next slide, please. Having formed a union, you have additional rights. The employer must maintain the status quo at the workplace until the parties have had an opportunity to bargain in good faith. The employer must provide your bargaining representative with information that's relevant and necessary to bargaining and bargaining well, to competently bargaining. The employees can request union assistance at meetings with the employer, and employees will have the opportunity to negotiate a host of other rights in a contract. Some of the typical ones that have been negotiated for in faculty contracts include a grievance process, a more comprehensive or fair evaluations process that goes beyond just student evaluations, a reappointment process. These are all things that different unions and different at different workplaces will bargain for, and they'll all look a little different, but you have the right to bargain for that. Next slide, please. So just a word on the process. There are two to form a union, but before you decide to go with one or the other, you know, a predicate for all of this is organizing and designating and figuring out who you want to designate as your bargaining representative. Once you're at a point, you know, you're organizing, you think this will happen, you can ask your employer to voluntarily recognize your union. And in order for this to be legitimate, you have to present 50% plus one of your bargaining unit has designated and authorized a collective bargaining representative. Your employer may not voluntarily recognize you, but that is an option if you have an employer who's willing to recognize you. You can also file a petition for an NLRB conducted election. And in order to meet what they call the showing of interest for a board conducted election, 30% of your bargaining unit must express interest. And typically, in our organizing campaigns, we've used authorization cards to indicate that the employee is interested in having an election. Then, at that point, the parties will have an opportunity to work out the basics of the election and come to and sign a stipulated election agreement. And that basically means that you sort of designate, okay, how is the election going to occur? Usually in faculty elections, it's been mail ballot elections because faculty have such different schedules and aren't always in the same place at the same time. Figuring out who's in the bargaining unit and who's not in the bargaining unit, who may be eligible to vote in this election or not vote. Those are all things that you would work out with the employer prior to the election. And then an NLRB election will usually be held about 6 to 7 weeks later. In order to be successful, your union must get 50% plus one of the total votes to become the exclusive collective bargaining representative. And so that's how you file for. So this concludes my overview of the federal rights of private sector workers to organize. If you're looking for additional legal resources, the NLRB website is very helpful, and the link is right there. They have the act, the total act, if you want to read through it. There's more information about your rights. They have forms that you can fill out if you wanted to file a petition or file a charge, etc. It has the regional office locations, and there's quite a bit of legal information about cases, current cases, and then case law, as well as the board's manuals that are all online, and you can dig through them to your heart's content. So thank you for joining me and your labor rights.
That was fantastic. Can you hear me okay?
Yes, you're a little delayed. I can.
Oh, okay. Sorry about that.
That's okay. Google Hangout.
Yeah, Google Hangout. No, that was really fantastic. That was a lot of information, and I'm sure that's incredibly valuable information for a lot of people who are just getting started trying to figure out this whole organizing thing. There's a lot of information that I feel like is probably a lot of adjuncts feel is just completely secreted away someplace. They don't have no idea how to get to that information. So that was fantastic. It was really, really good information.
Great. I'm glad you found it helpful.
We did have a few questions submitted, but actually I feel like you answered all of the questions in the course of your presentation. So I don't necessarily know that we need to go over them.
Great.
I think it was really, yeah, it was just very, very complete. So I really appreciate it.
You're welcome.
Okay. Well, we'll go ahead and conclude then. And thank you, everyone, for joining us today and for making the time to chat. Be sure to join us tomorrow when our final session will cover the history and future of the national effort to organize adjunct teachers. And one quick reminder, the Adjunct Action Network is a member-driven organization. So if you'd like to continue to see conversations like this one take place, please head over to adjunctaction.com and join the effort. Thank you so much.